5,000 as compensation was imposed upon the petitioner in his absence while invoking Section 20, Subclause 1 of the Right to Information Act 2005. However, my lord, Section 20, proviso to Section 20 of the Right to Information Act stipulates that no penalty can be imposed upon the public information officer in his absence. And my lord will find the impugned order.
He did not provide the requisite information within this time,
My,
stipulated time. He did not provide the information.
my lord, all the information was published, was furnished to the respondent, and it was not communicated to the respondent has not revealed, communicated this information, passed this information to the commission. And my lord will find this, find the impugned order at page number 63. And my lord, this order was passed,
Page number.
page number 63, Annexure 21. My lord, this order is not legible, so at page number 65 is the type copy of the order. My lord, admittedly, when this order was passed, the public information officer was not present. So
Why admittedly, is there any reflection in the order?
it is,
No, you have said that admittedly he was not present, whether there is any reflection.
my lord, it is there in the order. I'll read out the order, my lord. Whereas the 11th hearing is held on 8 January 2024 related to the affix number so and so appeal. The appellant Tachuk Ragyur present during the hearing along with his representative advocate, namely R. Tamin, but PIO cum DLRSO Sri Takam Titus found absent during the hearing without intimation to the commission the reason of his absence from the hearing. So he was absent, admittedly absent on that day. And my lord, the appellant petitioner is posted in interior part of the Arunachal Pradesh, that is Indo-China border. So when this the summon notice sent by the commission always reach after the next picks for hearing of the cases. I'll take my lord to the page number 37, page number 37. For instance, my lord, 37. This is the summon notice issued to the petitioner. Whereas in connection with so and so, your personal appearance is required for the commission on 6 February at 10:30 a.m. And my lord, this summon notice was received by the petitioner on 26 April 2023. So after the expiry,
This is you have written, received on. How can you say that this petition, this notice was received by him only on 26th of April? Because there is no signature, nothing is there, only received on so and so.
my lord, in the page number 46 also, if we see, it was fixed for the whereas in connection with affix number so and so, your personal appearance is required for commission on 8 May And my lord, if we
This was
see
this was the subsequent notice, second notice.
subsequent notice, and if we see the received on 10/5/2023, and it was put up by the dealing assistant on 16/5/2023. So summon notices sent by the commission used to receive by the petitioner much later, because the petitioner is posted in interior part of the state. So hardly it takes lot after 2-3 months only the summon used to receive. Even the summon which was summon notice which was sent for appearance on the 8/1/2024 was not received. And the petitioner came to know about this order as it was published in the Times of Arunachal Pradesh. It was published on 9 January 2024.
So we made the respondent, only sole respondent is here, no?
Yes. Hello. My lord, my only prayer is that since they have failed, since the order penalty was imposed in the absence of the Public Information Commissioner, so it may be stayed in the interim. T. Sunil.
Mr. T. Sunil, the learned counsel for the petition. This is an application under Article 227 of Constitution of India against the imprint order dated 8/1/2024, passed by State Commission in APIC numbers 730/2022, 731/2022, and 732/2022, whereby penalty of rupees 25,000 was imposed along with rupees 5,000 as compensation upon the petitioner in his absence. It is submitted by the learned counsel for the petitioner that the present petition has provided all the necessary information as asked, as sought for. However, he could not appear before the commission as he received the notices, both the notices after, as he received the first notice on 26/4/2023, which was issued on 19 January. When he was asked to appear, he received the notice on 26th of April, and the notice, so there is not any date of 6th of February.
6th of February.
Yes. Twenty-four, 23, wherein he was directed to appear before the commissioner on 6th of February 2023, and the subsequent notice also he received after the date fixed for his appearance on 10th of May 2023. As post office is posted in a very remote area, the notices could not reach to him within the time, and for which he could not appear before the commission. In his absence, the order was passed with a maximum completion period with a maximum penalty of rupees 25,000 against him, along with a compensation of rupees 5,000 inflicted upon him for the against the said order. The present petition has been filed by the petitioner. First one, considering this submission made by the learned counsel for so and so, and issue notice to the sole respondent so and so through registered AD and as usual process. Further, further considering this submission made by the learned counsel for the petitioner, let the order dated, it was order dated
8/1/2024.
Huh?
8/1/2024.
It was the 8/1.
8 January
Page number,
2024.
page number
The 60, page number 63.
65.
63.
Okay,
65 is the type copy.
that copy.
Type copy.
Dated 8/1/2024.
8/1/2024.
The execution of order dated 8/1/2024 passed by the State Information Commissioner is hereby state till next date of listing. The place and that will be accordingly listed after 4 weeks. It will be listed after 4 weeks as the date to be fixed by the registry, and you take steps for the respondent, sole respondent.
In the interim, stay
Yes, I agree.
entry.
But take steps within this week. Huh?
Much obliged.
This civil legal petition is preferred against the Infill Kebang decision dated 30/9/2023 passed by Tekang Bane Kebang without
Kebang decision.
Kebang decision without having any power and jurisdiction. Madam, Kebang is
But when it was passed?
on 30/9/2023.
23 only.
Yes. Madam, Infill Kebang is at page number 17. And the case is that in the year 1998, the land dispute was arose between the petitioner and the respondent number 1. Accordingly, the dispute land was decided by the Deputy Commissioner Pasigat on 12/10/1998 in favor of the petitioner. And the decision of the Kebang Deputy Commissioner was never challenged by any party. Since from 1998 to 2023, the said land is under the possession of the petitioner. Surprising, after 25 years, the respondent number 1 initiated a Kebang. Accordingly, Kebang was conducted by the Tekang Bane Kebang and reviewed the order of Deputy Commissioner. This, my lord, this Tekang Bane Kebang is a guest authority. They have no power to review the order passed by the Deputy Commissioner. As per the AFR 1945 as well as the Arunachal Pradesh Civil Code Act 2021.
Civil Code Act. AFR and Civil Code Act is also there. Which number? Which volume? Volume?
As per the AFR
Volume.
section 48.
Volume?
Section 48.
No, section 40, volume 1.
Yes, my lord, volume 1. Page number 67.
Page number?
67. Volume 1, page number 67. Section 48. Like, an appeal shall lie to the High Court from an original decision of the Deputy Commissioner if the value of the suit is not less than 500, or if the suit involves acquisition of trial of right or custom or the right to possession of the immovable property. While the decision passed by the Deputy Commissioner shall lie to only High Court, not by the blessed authority.
By what, but the other civil forum is not applicable. They can, whether they can appear before the other civil forum, except the High Court also.
As per Arunachal
They have
Pradesh
the right, I think.
Civil Code Act
Hmm.
2021,
Hmm.
This Deputy Commissioner was replaced by District Court.
Yes,
District Court.
Hmm.
But in
that's
that
what I'm asking.
act also, appeal lie to the High Court. Now that is in page number 24 of my petition. I have annexed the act. Page number 24, my lord. My lord, section 15, appeal.
Hmm.
An appeal from a decree or order passed by the court of district judge and court of an additional district judge in original suit and proceeding of civil nature shall, where such appeal are allowed by law, lie to the High Court.
This, the order was passed by the DC prior to the implement of this one.
Yes, yes, yes.
Yes, then, what is your prayer?
Madam, at this respect, madam, a notice will be issued by respondent, and in the meantime, my input can be considered.
What is the intent?
Madam, during the pendency
It is
of
already
this
passed only.
petition,
39/2023, the order
yes,
has been passed by the
definitely.
Kebang.
yes, can be.
Had Mr. Ahmed. Omar, had Mr. Omar to done it counsel for the petition. How many respondents are here?
Madam, two respondents,
On the private respondents?
yes, all private.
This is an application under section under article 227 of the Constitution of India, setting aside the decision slash judgment dated 39/2023, passed by Tekang Bane Kebang. Tekang Bane Kebang. Full stop. It is submitted by the Learned Counsel for the petitioner that there was a dispute between the petitioner and the respondent in the year 1998, and which was settled by the Deputy Commissioner. Yeah, have you annexed the order of 12/10/98?
Yes, madam.
Right.
Page number 34.
Passed by the Deputy Commissioner. Deputy Commissioner, which district this one?
East Siang District, Pasighat.
East Siang District. Deputy Commissioner, East Siang District, Pasighat. Dated 12/10/2000, dated 12/10/1998, in favor of the present petitioner, and which was not challenged by the respondent. And however, full stop. However, after 25 years of the said order, the respondent moved an application before the Kebang Canon, the Kebang. Taking Bane Kebang, and but in that Kebang, you were also present there.
My lord, I was present in the morning. I am informed that this matter has been already decided by the Deputy Commissioner Pasigat. So.
No, 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 I'm not on that. In Kebang, before Kebang, you were also there.
Yes.
That time you remain silent.
My lord, I am informed at Kebang that this matter has been already decided by the DC. So
Hmm.
this matter, this Kebang may be cancelled. After that, I have left the Kebang.
Before so and so. And when Kebang was called for, the Bichar was called for,
My lord, 39/2022.
on that day itself.
On same day.
Accordingly, the Kebang was called for on 39/2023, and wherein the petitioner raised objection and submitted that as the matter has already been decided by the learned Deputy Commissioner Ms. Yang so and so, the Kebang authority has no, the Kebang has been authority to make any decision over against the order of the Deputy Commissioner. However, he could not be present during the entire proceeding, and finally, on 39/2023, it was passed in favor of them.
Yes. My lord,
And-
no, some portion of the land has been decided in favor of the respondent number 1.
And by the order dated 12/10/98, some portion of the disputed land was decided in favor of the respondent, full stop. Again, on being aggrieved by that order of the Kebang, the present petition has been filed by the petitioner. Full stop. Next, where it is submitted by the learned counsel for the petitioner that as per the no, they submitted that the Deputy Commissioner is Young District so and so had passed the order prior to the implementation of the Civil Code Act in Arunachal Pradesh, and as per 48, no?
Yes, section 40.
And as per section 48 of AFR, it is clearly stated that the appeal shall lie to the High Court only against the order of the Deputy Commissioner if the value of the suit is not less than 500. But here in the instant case, the respondent has moved an application before the Kebang seeking a decision against the order of the Deputy Commissioner, which is not at all maintainable. Further, it is submitted that after the implementation of court, civil court Arunachal Pradesh Civil Courts Act 2021, also the appeal died before the High Court as the order District Court of Senior Testimony. Senior office, we will just hear. Submitted that next we are considering this submission. So correspondent number 1 and 2. Mr. K. Considering this submission. Present provision of AFR Arunachal Pradesh as well as the Civil Code Act. Justified to stay the execution of the decision of Kebang dated 12/10, 39 to 39. This is the matter. 33 till the release date of this.
Mayor, Your Honor. I have filed this application under section 482 of CRPC for the quashing of criminal proceeding in connection to Pasigat PS case number 47, 2022. It's a joint petition that is filed by the complainant and the victim's wife and the accused person. Your Honor,
Victim's wife, it is a, what's it?
yeah, deceased,
Dead
yeah,
case.
he is
Dead
no
case.
more.
Okay.
Your Honor, on 22/04/2022, an FIR was lodged by the complainant in the police outpost of Mibo, where an accident was caused by an accused person. And on that accident, due to the cause of the accident, the victim lost his life. And as for after the FIR was lodged, an investigation was carried out. And according to the investigation, it was found out that due to the poor visibility, because at the time of the accident, there was some heavy rainfall. So when the accused was coming from his place, so he could not see properly due to the poor visibility. That unfortunately, the accident was. So, Your Honor, today I have filed this because the parties, who are the complainant and the deceased wife and the accused family, they have made a settlement outside the court. So I like to kindly request you to turn to page number 50, where the case settlement deed are made. It was made on 24 April 2022, where they have made the case settlement that the victim's wife had received a sum of 1,50,000 rupees as a compensation from the accused family, and she agreed that she would like to withdraw the cases because the accused was at that time was in the 21 years of age, and due to all means due to that incident, he could not study further, and for 1 year he left his study. So on that cases, for his future, the victim's wife have decided to withdraw the cases. And Your Honor, I would like also that money received is on page 52, and page 53 is the declaration that is given by the deceased wife. So, Your Honor, I would like to pray that kindly this matter may be admitted and may please call for the NCR.
Your Lordship, the settlement has been entered by not by the accused but accused mother, because Your Lordship, so far as the criminal case is concerned, the
Accused mother?
accused mother, not the accused.
No, accused wife.
Accused wife.
Sorry, accused mother. Yeah, because at that time the accused was.
21 years is not minor, Your Lordship.
Why he did not enter into the settlement agreement?
During that time, Your Honor, the accused was after the accident for almost a week. The accused was in the hospital, and after that, after the investigation, he was taken to
Incident,
custody.
incident took place on which day?
Yes, Your Honor.
Incident took place when? When incident took place?
Incident took place on 22 of April 2022.
He may be hospitalized for 1 week.
Yeah, for almost 1 week, he was in hospital, and
We will not be terrible. I think we can advise to.
Your Lordship, otherwise, Your Lordship, if they have settled the matter, Your Lordship, they may be called before this court, both the parties, Your Lordship.
yes, Your Honor.
Otherwise, he may withdraw this one and.
Yes, Your
file
Lordship.
the-
Otherwise, they have to withdraw it because the settlement is entered by the mother and mother of the accused, and settlement deed was entered into on 24th. And the alleged incident has happened on 22nd of April. Immediate after 2 days, Your Lordship.
Immediate after.
Yes, Your Lordship.
Of course, they are just.
Yes, Your Lordship. That is there.
Otherwise, you can draw, we can ask the party to appear before the court, or you can withdraw this one and can file a petition press.
Yes, Your Honor, we can ask the party to be present.
But
on
who
this.
will identify? That
Yes, that is. Let them come with their I-card, Your Lordship, in that case. In earlier occasion also, Your Lordship, when this court find it necessary, this honorable court has directed the accused and the victim to appear before this court personally with their respective I-card, Your Lordship. Otherwise, Your Lordship, the sections is 307A and 279. Your Lordship, these offences are no doubt in the earlier occasion also by the coordinate bench. As Your Lordship, I've seen 2 cases where this court has interfered. But here, Your Lordship, on those cases, the victim was the party and the accused were the party. Yes. But here, the accused is not the party and no doubt victim is deceased.
Are the SMS? URMS? Our name is G. Julpi, the learned counsel for the petition. Also have Mr. Created, the learned additional PP, appearing on behalf of state respondent. This is an application on section so and so in connection with so and so. This is a joint application filed by so and so in connection with so and so for quashing and setting aside a criminal proceeding. Proceeding number so and so pending reporting so and so. It is charged matter or?
Yes, sir, charge sheeted, your lordship.
The court of so and so. Yes, madam. It is submitted by the learned counsel for the petitioner. That matter has already been settled between the parties and the mother of the accused and the complainant as well as the and victim. Who is he?
Wife,
This is fine.
And the wife of the deceased is also entered into an agreement, settlement agreement, and they have mutually settled the matter outside the court. And hence, the present petition has been filed for quashing the criminal proceeding pending against the petitioner number. Oh, he is not the petitioner also. Petitioner, he is the petitioner.
lordship,
Yes. Petition number 1 is the complainant.
Petitioner number 1. First. In that context, next para, in this context, Mr. T. the learned additional PP has submitted that though this is a joint application filed by the accused, the complainant and the wife of the victim, but from the settlement agreement, it is seen that the agreement was between the mother of the accused and the wife of the deceased. And hence it is submitted that in presence of the accused and the part of the presence of the physical presence of the accused as well as the other parties would be required and required as there is no reason to as there is no reason for the mother of the accused to enter into an agreement when the accused was 21 years of age at the relevant time of incident. Considering the submission made by the learned additional PP, let the accused as well as the wife of the victim, mother of the accused, and the complainant be physically present on the next date with their proper identity card, etc.
your lordship, call for the scan copy of the LCR.
Also call for the scan copy of the LC. Let the matter be listed after 2 weeks.
Yes, your lordship, after 2 weeks.
Much obliged.
Oblige, your lordship.
May I please edit it?
Yes.
This is an application under section 482 CRPC read with 226 of the Constitution of India, seeking the quashing of the FIR number 175 of 2023 PS Papam Pare. Your Ladyship, before going into the merits and the facts and circumstances of this case, I wish to rely upon the pleadings of the writ petition criminal number 322 of 2019 filed in the Honorable Supreme Court, whereas the Honorable Supreme Court was pleased to stay around 53 FIRs of similar and identical subject matter. Your Ladyship. If your Ladyship could have synopsis, I have also marked it in the synopsis. Your Ladyship has it. The present petition is filed raising substantial question of law of general public importance. Similar questions to the best knowledge of the petitioners herein are also pending before the Honorable Court in writ petition number 31 of 2017, writ petition number 17 of 2019, and writ petition criminal of number 198 of 2019. The petitioner herein are the distributors, independent representatives of Vihan Direct Selling Private Limited, QNet Limited, and are aggrieved by the filing of FIRs against them. The petitioners herein apprehend that there may be coercive action by the police, as the petitioners are also distributors, IRs of the Vihan Direct Selling. Vihan Direct Selling follows a multi-level compensation commission plan for its business. Some of the petitioners herein are agreed by the rejection of their application for anticipatory bail by the Honorable High Court of Telangana in relation to FIR number so-and-so, registered by police station so-and-so. in Telangana state, an FIR number 206 of 2019 registered by police station of Singhad Road, Pune in the state of Maharashtra, and FIR number so-and-so registered by police station of so-and-so. Further, some of the petitioners apprehend coercive action taken by the respondent states named herein against the distributors, IRs of IRs are the independent representatives of Vihan Direct Selling Private Limited, including the petitioners here. It is pertinent to note that the only association that the petitioners have with the persons against whom these FIRs have been filed is that they are all acting as direct sellers of the above mentioned entities, namely Vihan Direct Selling Private Limited, Unit Limited. It is also stated that the police authorities in many states have either issued summons against or arrested individuals, though they may not have been named in the FIRs or were associated in the commercial transactions for which these FIRs were filed, merely on the basis that the individuals were associated with Vihan Direct Selling Private Limited. That the rights of the petitioners are conferred by the Constitution of India under Article 14, 19, and 21 are being abridged by the action of the state authorities. Further, it is stated that the Honorable Court has given protection to so-and-so and so-and-so who are the shareholders of Vihan Direct Selling Private Limited from coercive action in criminal writ petition number 17 of 2019 in connection with 51 FIRs mentioned therein. Further, in writ petition criminal number 198 of 2019, this Honorable Court also gave protection from coercive action to some distributors, IRs, in connection with FIR number so-and-so filed at so-and-so. The petitioners are not able to proceed with trade and profession despite being part of a legitimate business module, which the petitioner humbly submit is a violation of their rights and freedom as envisaged in the Constitution of India.
So you want to submit that this in a similar nature of matters, the order has been passed by the Honorable.
Indeed, Your Ladyship.
Now,
So much so that-
what is your petitioner's case? Case of your petitioner's is as a brief?
Your Ladyship, we are also independent representatives.
Yes.
We introduced the complainant bought certain products from the e-commerce website. The products were delivered to them. After that, they were dissatisfied. They should have filed a consumer protection case, as also the Supreme Court also holds that this is a case of a pure civil nature, and ideally, consumer complaint should have been filed under the relevant provisions. There is also a Karnataka High Court judgment in which the Honorable Court was pleased to quash the entire proceedings, holding that it is a case of a pure civil nature, and the right forum would have been filing a complaint in the Consumer Protection Act. So we are also identically and similarly placed, Your Ladyship. If we go further in the synopsis, the entire module of the company, because it is a direct selling module, multi-MLM, they call it multi-level marketing module. So this was ratified by a guideline which was issued by the Government of India in 2016, which was subsequently notified in the state of Arunachal Pradesh as well. That guideline also states that if there is any problem with any kinds of services, the correct forum would again be approaching the Consumer Protection Court and not giving it a color of criminal nature and filing FIRs after FIRs. So, my lords, it so happened that after 2016, N number of FIRs were being filed throughout the country, my lords. That is when the petitioner started approaching the Honorable Supreme Court of India, wherein the Supreme Court stayed the entire proceedings. If Your Ladyship has the new folder that I've just passed on. Page number 1 is Vihan Direct Selling Private Limited versus Union of India. Page number 2 is the order of the Honorable Supreme Court. This petition is still pending. The bunch of petitions are still pending before the Honorable Supreme Court. The Supreme Court was kind enough to grant stay, Your Ladyship. They say, for the ground stated in the writ petition, there shall be stay of further proceedings in all the 20 FIRs in terms of the prayer at clause C of the petition pending hearing and final disposal. Having regard to the fact that the petition number 2 and 3 before us, so-and-so, they are directed to be released on bail. Now, the FIR, the subject matter of the FIR in all these cases is identical and similar in nature to the FIR at hand, Your Ladyship. If Your Ladyship may be kind enough to have FIR for a moment. It is at page number 34.
34.
34. Page number 35 is the operative part. We would like to lodge a complaint against our two closest friends, that is Miss Bani Mangam, daughter of so-and-so, presently residing in Guwahati, contact number so-and-so, and Miss Mepung Riang, daughter of so-and-so, residing in Guwahati, contact number so-and-so. Both of them approached us to do some e-commerce business named as so-and-so. The questions we asked were if it is an MLM company or product selling company, to which they denied. They started influencing us in an unscrupulous way, allowed us to invest money. And as a good friend, we trusted them, and as per the direction, different amount were transferred on different dates. Amount of rupees 1,20,000 and 4,50,000 under the years 2022 and 23. Amounts were transferred to their account, that is Bani Mangam SBI account number so-and-so and Mepung Riang GPay number so-and-so. And after some days of transferring money, they started avoiding our questions. And soon we realized that we are not getting any assignments as promised by them. They made us do a scripted video declaration in which we came to know that the company name is QNet and it is an MLM company. When we started asking for our money back, they started saying us to face legal consequences on the account of scripted KYC video. Gradually, we came to know that they created fake email ID on our behalf without our prior approval and failed to give us login credentials despite asking many times. With the help of my friends, we were able to log into the Gmail account. We came to know about the products purchased made through fake email IDs without any prior approval. The products were sent by QNet Vihan Direct Selling Company to our permanent addresses. And unwillingly, we had to receive it. By seeing the products bill, we realized that the products was purchased with half of our money. We even asked for the total bill receipt, to which they failed providing. We also sent mailed complaint letter against Bani and Mepung to the QNet company for taking action, as they failed to follow the guidelines, code of ethics, policy of the QNet company before taking the money. Till date, Gmail login credentials and bill receipts are not provided to us. We have been misled and misguided again and again. Your Ladyship may have page number 56. Page number 56 is the receipt wherein the products were actually delivered to them. Maya Digging ordered Trip Saver Basic worth rupees 610. Then page number 57, 58 is again the codes of the products that were bought by them. They were again delivered to their respective addresses. Page number 60 is also MS Kua Biodisk 3 for 1,190, which was again delivered on their respective addresses. Your Ladyship may see the red colored lines which are at page number 60, which says that they have to go and personally pick up certain products when they are delivered. So these people have also gone to pick up these products. Page number 61 is again a list of the products that were served upon them. Now, surprisingly, at page number 63, they have also applied to become distributor of QNet. That means after they had received the products, they wanted to become a part of this business model, and they applied, and it is dated 16th of March 2023. They are themselves applying to become a distributor. Now, my lords, the accused persons are independent representative, and in order to become an independent representative, they have to apply in the same form, my lords, distributor application form. Now, these people were also applying to be an IR. Page number 64 is another document which has been signed by the complainant, distributor application form. Annexure 10 at page number 65 is the list of the people, these people involved and approached to buy these products. So these people are not only, the complainant is not only buying their products for themselves, they are also trying to convince other people to buy the same products. Now, Your Ladyship, in my humble submission, no offense against me is made out. The sections that have been invoked in the FIR is 419, 420 IPC, along with other sections. Your Ladyship, in my humble submission, 415 is not made out because there is no dishonest intention and fraudulent intention on my part. Your Ladyship may have section 24 and section 25 of the Indian Penal Code for a moment. IPC.
Section?
Section 24. Your Ladyship, section 24 is where dishonestly has been defined by the Parliament. Your Ladyship has it? Whoever does anything with the intention of causing wrongful gain to one person or wrongful loss to another person is said to do anything dishonestly. Your Ladyship, there is not even a single penny that I have actually gained out of this. They transferred some money to me, and on the very same day that the money was transferred to the Uplink. Uplink is the company. And qua that money, the products were delivered to them. So if I am transferring the same account on the very same money on the very same day after receiving it in my account, there is no wrongful gain on my part. If there is no wrongful gain, that means there is no dishonest intention on my part. Your Ladyship may now have section 25, which is fraudulently. A person is said to do a thing fraudulently if he does that thing with intent to defraud but not otherwise. Your Ladyship, from the bare perusal of the FIR, it is very clear that there is no intention to defraud whatsoever. Your Ladyship may now have section 415 for a moment. (415) is where cheating has been defined. Whoever by deceiving any person, fraudulently or dishonestly, induces the person so deceived to deliver any property to any person, or to consent that any person shall retain any property, or intentionally induces the person so deceived to do or omit to do anything which he would not do or omit if he were not so deceived, and which act or omission causes or is likely to cause damage or harm to that person in body, mind, reputation, or property is said to cheat. Now, if there is no dishonest or fraudulent intention on my part, section 415 is also not made out. Your Ladyship may now have annexure A2. A2.
Page number.
A2 at page number 40, Your Ladyship. This is a judgment passed by the Honorable High Court of Karnataka at Bengaluru, wherein the court was pleased to quash the entire criminal proceedings, almost the same facts. Your Ladyship may now have page number 47, the operative part of the judgment. Further, a prima facie perusal of the FIR and the charge sheet, para number 29, Your Ladyship, reveals that the ingredients of the offence under section 417, 419 and 420 are not made out. The allegations pertains to payment of certain monies in anticipation of certain services. And in the event of a deficiency of service, the appropriate course of action would be to initiate proceedings under the Consumer Protection Act 1986 and not initiate criminal prosecution under the provision of the IPC. Your Ladyship, this is very important. The advisory issued by the central government in terms of the model framework guidelines on direct selling also recognizes this fact and specifies that the entire activity of the direct sellers and direct selling entities should be guided by the provisions of Consumer Protection Act 1986. The Honorable Supreme Court of India has repeatedly observed that criminal law should not be set into motion to settle civil disputes by giving such dispute a color of criminality. In Sagar Suri versus UP and Hira Lal Bhagwati versus CBI, the Supreme Court has observed that the matters essentially of a civil nature should not be given a cloak of criminal offences, and criminal proceedings should not be used as a shortcut for other remedies available in law. The court has further observed that in such instances, the jurisdiction under section 482 ought to be exercised to quash such criminal proceedings. The instant case is a typical case where criminal legislation which are not even remotely applicable to the circumstances of the case, have been invoked to substantiate the charges. The dispute, if at all, is between a consumer and a direct seller and ought to be adjudicated under the provisions of the Consumer Protection 1986. As a consequence, the FIR and the charge sheet are unsustainable and deserve to be quashed.
Yes, may it please your lordship. Your lordship, this case is still pending under investigation. Now, your lordship, my learned brother has submitted that whatever I have understood that, your lordship, his submission should be in favor of the whatever my brother is submitting. It should be in favor of that multi-level corporation itself, your lordship. But here is the allegation, it's against the individual. It's basically a networking business. As a layman, your lordship, we understand as a networking business where downline, upline, your lordship, equities are there, your lordship. Here the allegation is not against the company. It's against the person who has been recused for direct selling of the, your lordship, whatsoever, whether its product is pertains to cosmetic or any whatsoever, your lordship. But there is an allegation specific against the two person, your lordship. They, your lordship, may kindly come to the FIR because, your lordship, to entertain the 482 application for interfering the, your lordship, criminal investigation or proceeding, the court has to see whether the prima facie case is made out or not. That has to be looked into from the FIR because investigation is still in progress, your lordship. Your lordship may kindly come to FIR which they have annexed in page number 37, your lordship. The allegation is not against the, your lordship, company, your lordship. It's against the two individuals, your lordship. May I read, your lordship? I'll point out, your lordship. To the officer in charge, Itanagar PS, Arunachal Pradesh, which was filed lodged on 8/8/2023 FIR. Respected sir, we would like to lodge a complaint against our two closest friend, Miss Bani Mangam, daughter of so-and-so, presently residing in Guwahati, contact number so-and-so, and Miss Mepung Riang, daughter of so-and-so, residing in Guwahati, contact number so-and-so. Both of them approach us to do e-commerce business. Name is Conglomerate. The question we asked were if it's an MLM company or product selling company, which they denied. Now, your lordship, from this statement, it's a paragraph, it can be easily inferred that this is for the first time that they met each other. First time. It is not a case where they have already met each other and during the process, all these things has happened. It was for the first time they meet this person. Now, your lordship, second part. They start influencing us in unscrupulous way, elude us to invest money as a good friend. We trusted them, and as per their direction, different amount were transferred on different dates. Amount so and so were transferred to their account. Your lordship, the amount was transferred to their account, your lordship. The amount, it is not a case where amount was transferred to the company, your lordship. My brother has pointed out some annexer where says, your lordship, they tried to be the direct distributor. But here is a case, they has been eluded. The alleged to be eluded by two person to put money in their personal account, your lordship. And so, after some day of transferring money, they started avoiding our question. And soon we realized that we are not getting any assignment as promised by them. They made us to scripted video declaration. This is scripted, your lordship, video declaration, in which we came to know the company name QNet. Now they come to know about the company, existence of this company. And it is MLM company, the your lordship, multi-level, your lordship, something is there, company. When we start asking our money back, they start saying us to face legal consequences. On the account script KYC video, basically, your lordship, on the basis of the scripted KYC video, they have been, your lordship, gradually we came to know they create a fake email ID. Now, your lordship, come this person, fake email ID. They are alleging that the fake ID has been created by the accused person on our behalf without our prior approval and failed to give us login credential despite asking many times. With the help of my friend, we were able to log in the Gmail account. We came to know about the product purchase made through fake email ID. Why fake email ID, your lordship, if their intention was bona fide one? Without our prior approval, the product were sent by QNet, Bihan Direct Selling, which my brother has pointed out, Bihan Selling. The allegation is not against the Bihan Direct Selling company, to our permanent address, and unwillingly we had to receive it by seeing the product. We realized the product was purchased with half of our money. We even asked for the total bill received to which they failed providing. We also sent mail complaint letter against Bani and so to QNet. Your Lordship, their intention, they have made a complaint to the QNet. They have a bona fide belief that this company will take action against them because they are indulging in all this malified act, Your Lordship. Company for taking action as they fail to follow the guidelines. No doubt they are aware of the guidelines, code of ethics, red line policy of QNet company before taking the money. Till date, Gmail login credential and bill receipt are not provided to us. We have been misled and misguided again and again. Therefore, sir, kindly help us to register the case. Now, Your Lordship, it's very clear. It's not against the company. They are not saying the company has done this and that. It's against the employee of the company or the recruitee who are involved in this networking business, and prudently they are influence the person to invest money and put that money into their own personal account, Your Lordship. So, Your Lordship, at this stage, Your Lordship, what this court has to be considered at this stage is whether the FIR disclosed the commission of the prima facie case or not. From the bare reading of this FIR, Your Lordship, the ingredient of section 420, Your Lordship, attracted, Your Lordship. That is the, Your Lordship, dishonest intention. And Your Lordship, that whether their intention was dishonest or not, that cannot be, Your Lordship, inference cannot be drawn from it at this stage, drawn from the FIR. For that, Your Lordship, fair investigation has to be carried out to unearth the truth, Your Lordship. There is no any allegation against the company that the company has approached them to put this much amount, that much amount. It was 2% which has been named in the FIR. They induced them, Your Lordship. And as on that, Your Lordship, from the FIR, it can be presumed that, Your Lordship, the prima facie case is made out against them. If prima facie case is made out, Your Lordship, at the stage of investigation, there is a, Your Lordship, judgment from the Honorable Supreme Court, the Nyarika infrastructure case, Your Lordship, which I will rely the guidelines, Your Lordship, under what circumstances, Your Lordship, the court can stifle the, Your Lordship, investigation or interfere with the investigation. Para 80, Your Lordship, the guidelines is there. This was reported in 2021, SCC Online, SC 315, para 80, Your Lordship. In view of the above and for the reason stated above, our final conclusion on the principal core issue, whether the High Court would be justified in passing an interim order of stay of investigation and or no coercive steps to be adopted during the pendency of quashing petition under Section 482 CRPC and or under Article 226 of the Constitution of India, and in what circumstances and whether the High Court would be justified in passing the order of not to arrest the accused or no coercive steps to be adopted during the investigation or till the final report charge sheet is filed under Section 173 CRPC, while disposing of, not entertain, not quashing the criminal proceeding, complaint, FIR in exercise of power under Section 482 CRPC and or under Article 226 of the Constitution of India. Our final conclusion are as under. Police has the statutory right and duty under the relevant provision of the Code of Criminal Procedure contained in the Chapter 14 of the Code to investigate into a cognizable offense. 2. Court would not thwart any investigation into the cognizable offense. 3. It is only the case where no cognizable offense or offense of any kind is disclosed in the first information report that court will not permit an investigation to go on. The power of quashing should be exercised sparingly with circumspection, as it has been observed in the rarest of the rare case, not to be confused with the formation of the context of death penalty. 5. While examining an FIR complaint, quashing of which is sought, the court cannot embark upon any inquiry as the reliability or genuineness or otherwise of the allegation made in the FIR complaint. 6. Criminal proceeding ought not to be scuttled as the initial stage. 7. Quashing of the complaint FIR should be an exception rather than an ordinary rule. 8. Ordinary, the court are barred from usurping the jurisdiction of the police, since the two organs of the state operate in two specific spheres of activities, and one ought not to treat over the other sphere. 9. The function of the judiciary and the police are complementary, not overlapping. 10. Save in exceptional case where non-interference would result in miscarriage of justice, the court and the judicial process should not interfere at the stage of investigation of the offences. 11. Extraordinary and the inherent power of the court do not confer an arbitrary jurisdiction on the court to act according to its whim or caprice. 12. The first information report is not an encyclopedia which must disclose all facts and details relating to the offense reported. Therefore, when the investigation by the police is in progress, The court should not go into the merit of the allegation in the FIR. Police must be permitted to complete the investigation. It would be premature to pronounce the conclusion based on hazy fact that the complaint FIR does not deserve to be investigated or that is amount to abuse of process of law. After investigation, if the investigation officer finds that there is no substance in the application made by the complaint, the investigation officer may file an appropriate report summary before the learned magistrate, which may be considered by the learned magistrate in accordance with the known procedure. 13. The power under section 482 is very wide, but conferment of the wide power required the court to be more cautious. It casts an onerous and more diligent duty on the court. 15. However, at the same time, the court, if it think fit, regard being held to be parameter of quashing and the self-restraint imposed by law, more particularly the parameters laid down by this court in case of KP Kapoor Supra and Bhajan Lal Supra, has the jurisdiction to quash the FIR complaint. When a 15. When a prayer for quashing the FIR is made by the alleged accused, and the court, when it exercises the power under section 482 CRPC, only has to consider whether the allegation in the FIR disclosed the commission of cognizable offense or not. The court is not required to consider on merit whether or not the merit of the allegation make out a cognizable offense, and the court has to permit the investigation agency police to investigate the allegation in the FIR. The aforesaid parameter would be applicable, and for the aforesaid aspect are required to be considered by the High Court while passing an interim order in a quashing petition in exercise of power under section 482 CRPC and or under Article 226 of Constitution of India. However, an interim order of stay of investigation during pendency of the quashing petition can be passed with circumspection. Such an interim order should not require to be passed routinely, casually, and or mechanically. Formally, when the investigation is in progress and the facts are hazy and the entire evidence material is not before the court, High Court, the High Court should refrain itself from passing an interim order of not to arrest or no coercive steps to be adopted, and the accused should be relegated to apply for anticipatory bail under section 438 CRPC before the competent court. The High Court shall not, and as such is not justified in passing the order of not to arrest or no coercive steps either during the investigation or till the investigation is completed and or till the final report charge sheet is filed under section 170 CRPC, while disposing of the quashing petition under section 482 and under Article 226 of the Constitution of India. Even in case where the High Court is prima facie of the opinion that the exceptional case is made out for grant of interim stay of further investigation, after considering the broad parameter while exercising the power under section 482 CRPC and or under Article 226 of the Constitution of India referred to herein above, the High Court has to give brief reason why such an interim order is warranted and or is required to pass so that it can demonstrate the application of mind by the court and the higher forum can consider what was weighed with the High Court while passing such an interim order. Whenever an interim order is passed by the High Court of no coercive step to be adopted within the aforesaid parameter, the High Court must clarify what does it mean by no coercive step to be adopted as term. No coercive step to be adopted can be said to be too vague and or broad, which can be misunderstood and or misapplied. And Your Lordship, in the present case, in present kind of cases, Your Lordship, most of the time your offense under section 420 is committed during the commercial transaction only, Your Lordship. And Your Lordship, there is no any embargo as such. When there is a dispute regarding commercial transaction, a criminal proceeding cannot be initiated, Your Lordship. From the face value of this, Your Lordship, FIR, a prima facie case is made out at this stage, so no interference is called for at this stage, Your Lordship.
Leadership, I think my learned friend missed the point when I started with writ petition criminal number 322 of 2019. That writ petition has been filed by the independent representatives only, not by the company, before the Honorable Supreme Court. The Honorable Supreme Court on the very first date stayed the matter, Your Ladyship. Around 53 FIRs across the country have been stayed, independent representatives. That is why I was going through the synopsis and the pleadings mentioned therein, which are absolutely similar to the pleadings that we have taken in the present case, Your Ladyship. Now, Your Ladyship, if Your Ladyship can have page I of the synopsis that I have provided, the writ petition number 322 of 2019, the other one, Your Ladyship. Page number I of the synopsis.
Synopsis,
Synopsis. Page number I.
page number I.
I. Second paragraph, Your Lordship. Direct selling refers to the selling of the products and services directly to the end consumers, sans traditional retail shops. Direct selling eliminates middlemen involved in distribution of the products of the company. The products available in the retail shops are rarely sold through direct sales, and therefore a selling representative is the only source of buying such products or services. These distributors, IRs, can earn commission only once the sale of the product is concluded, and these commissions are based on the compensation plans of the direct seller. The products and services of Vihan Direct Selling, a private limited, QNet Limited, are marketed and sold by its network of direct sellers, distributors, IRs, such as the petitioner and the members of respondent number 5, who earn commissions only on the conclusion of a sale. So, Your Ladyship, this petition was indeed filed by the independent representatives, not by the company. And it has been stayed by the Honorable Supreme Court of India, and the grounds that have been taken are absolutely the same. Because these FIRs across the country are of the same nature, same allegations, similar allegations, Your Ladyship. Especially when there is a Government of India guideline that if there is any kind of dispute, you go to the consumer forum. Your Ladyship, no one is approaching the consumer forum, although it has been notified in the state of Arunachal Pradesh. It is stated that Vihan Direct Selling Private
Here
Limited.
question is that, it's not that, the consumer forum, but question is that, the allegation against these two individuals they brought, that they have misled the informant, rest of the money of 1 lakh or 4,50,000, whatever, and it was credited to their account, and by this way they have not submitted any legal of these things, and all. Finally, they have just disclosed that they were working on behalf of the said company.
Indeed, Your Ladyship, I
That-
bow down.
That much only.
From the
So-
record only, I will show as to how every statement in the FIR is a falsity. But I am not trying to go into the merits of the case.
Okay, then, do one thing, we'll call for the case diary also. What is the
Yeah.
progress of the investigation at present?
Yes, Your Lordship.
And then can be, matter can be, if the
Yes.
IO has already collected those materials as you have submitted,
Indeed, Your Ladyship.
your petitioners are on interim.
They are on anticipatory bail. They were
Anticipatory
arrested and they were released on bail within 20 days. 17th of November, they were released.
They were released on this.
One more, Your Lordship, issue is, Your Lordship may kindly come to page number 38, Your Lordship. Okay, sir.
It is stated that Vihan Direct Selling Private Limited, as well as the petitioner herein, who are distributors, IRs, do not guarantee, assure, confirm, or even allude to any returns, employment, and or interest to any of its customers and distributors or other IRs. The policies and procedure followed by Vihan Direct Selling, which contain an income and earning disclaimer, is prominently shown to all the customers, which clearly state that the commissions, which are the only earning of distributor IR, I have only earned commission plus the money that had come to me, and I have annexed bank account statements. If I am receiving 20,000 rupees, let's say on 26th May, it is only on 26th May I am transferring that amount to the uplink. Then how can you say that there is any wrongful gain on my part? If there is no wrongful gain on my part, there is no dishonest intention. If there is no dishonest intention, there is no 415. So, my lords, may let them file a reply. I have no problem, Your Ladyship. We
Your
can.
Lordship, and page number, as per the page number 38, Your Lordship, there are other victims also, Your Lordship.
Other?
Victims also, Your Lordship. May kindly come to page number 38, Your Lordship.
38.
Yes, Your Lordship. The FIR, copy of the FIR last.
Is the state saying that they are the victims, or is the complainant saying that they are the victims? Because the complainant herself was ensuring that more people join.
Your Lordship, we are not disputing whether they have joined the company or not. We are only some limited submission that this 2% has allured this person on the name of this company, and they have taken money. That much, Your Lordship.
The money has gone to the company only, no? And on the basis of that money, the products have been delivered to these people, the complainants. They cannot also consume the products and then say that we have been cheated. In the FIR, they say that they have invested this money, whereas they are paying the money. It's like I am going to the shop, e-commerce, let's say I'm going to Amazon, and I pay and I get the money, and then I file a cheating complaint and it gets registered into an FIR. How can it get registered into an FIR? That is my whole case, Your Lordship. You have also consumed the products. They have been delivered to your addresses. Now, how can you say that you have been cheated? And how can you even say that it is an investment after consuming all the products? So that is my whole case, Your Lordship.
Your Lordship, on page number 38, the other victim's name were also annexed, Your Lordship. The victim of the accused person.
Maybe,
Annexed.
so that may be reviewed in the case diary also,
Yes,
if any other statement of any other witnesses or victims have been already recorded by
Yes,
the
Your
IO,
Lordship.
that will be revealed by the case diary.
yes, Your Lordship. Your Lordship, they has to implead them as a party. Notice has to go, Your Lordship.
Implicate them as a party whom?
Why?
The victim, Your Lordship.
They will implicate them as a party. They are victims. If suppose they are the victims or there are some other victims are also there,
Yes, Your Lordship.
most probably their statements are already been recorded by the IO. That may be.
Yes,
The
Your Lordship.
question of impleading those victims will not matter.
Okay, Your Lordship.
You are appealing on behalf of one A Likha or your good name?
My name is Shrey Sharawat.
Huh?
Shrey Sharawat.
Shrey Shravan. How do you
Ms.
say Shrey
Likha is the
Shravan?
filing counsel.
The Learning Council appearing on behalf of the petition, and also her Mr. T.A.T. the Learned Additional PP appearing on behalf of state respondent. This is an application in section so and so in connection with so and so for quashing the FIR. You name that the FIR. FIR dated so and so in connection under section so and so in connection with so and so. It is submitted by the Learning Council for the petition that from the petitioners are the only the bona fide employee of the company, namely Print.
Your Ladyship, we are independent representatives. We are not the employees of the
Sorry,
company.
independent representative, the company namely Q and ET, yeah. Q and ET, big letter, and capital letter, and is an MLM company. Full stop. Further, it is submitted that the money which has been given by the present informants, the product has already been delivered to the customers, and they have already annexed some of the documents in connection with to prove the delivery of those products to the person concerned. Further, he submitted that from the plain reading on the FIR as well as from the annexations which have been annexed by him, it is seen that there is no material wherefrom it can be concluded that he is the fraudulently or fraudulently induced the so and so to deliver money to attract section 415 against the present petitions. Substantiate the plea of the petitioner, the learned counsel for the petitioner also annexed several documents as well as the you have annexed all these, no?
These are the orders of the Honorable Supreme Court of India. They are not a part of the record. They have been
Yes, yes, yes.
supplied.
Orders of the Honorable Supreme Court passed in similar kind of similar nature of petitions. wherein
Involving IRs and the QNet, the same company, everything is the same.
involving IRs and the QNS of the same company, and wherein all the criminal proceedings were quashed by the learned Honorable Apex State proceeding. State proceeding was stayed by the Honorable Apex Court, stating that this is a matter where the complainant can approach the proper forum, that is the consumer forum. Next, madam. In this context, Mr. T.A.T., the Learned Additional PP, has submitted that this is a case where the prima facie a case has been established against the petitioners under section 4. The case was registered under 415 and 420.
420, Your Lordship, and
419 and 420, 66,
41?
419, 420, 34.
419 and 420 of the IPC. And for the submitted
406 as well. 419, 420, 406, 34 IPC.
419,
420, 406,
Hmm.
34 IPC.
406.
Read with section 66C, capital
IPC read with section
capital C,
66,
66
IT Act.
66C
C,
and
66D, IT Act,
66C and 66D IT Act.
2000.
2000. Further, we submitted that the case is very nascent stage of investigation, and at this stage, if the criminal proceeding is paused and without enabling the IO investigating officer to further to investigate the case in its proper way, then it may cause prejudice to the informant side as well as the investigating agency, the informant side. In this context, he also relied on a decision of Honorable Apex Court reported in 2021, SCC Online SC 315, wherein there's some guidelines where there were some guidelines by the Honorable Apex Court in para 80 of the said judgment. Considering the submission made by the learned counsel for both sides and considering the entire aspects of the case, I find that the case diary will be required to truly to arrive at a just decision. Accordingly, I find it necessary to call for the case diary at this stage. Let the you want to give any date?
Lordship,
As we will give you date as per your convenience. There's
Yes,
just
yes, Your Lordship, notice has also to go, notice has to go to the respondent number 2 and 3, Your Lordship. Yes.
issue notice to the private respond number 2 and 3. Steps will be taken by the petitioner through jurisdictional police station as well as through jurisdictional police station. Notice through jurisdictional police station or through your office will go.
Your Lordship, through jurisdictional PS will also work, or through us
Through
also.
your-
Yes.
Through jurisdictional police, rotate through the office of the public prosecutor. Yes, case diary. Do you have
Yes, Your
anything?
Lordship, 16th, Your Lordship.
16th of February it will do?
Yes, Your Lordship.
16th of February 2024, case diary. Well, I have not passed to the detail order because it is a preliminary receipt party.
great.
Oblige, Your Lordship.
If all these things will be recorded.
My lord.
Hmm.
Your Honor, this is an application under 482 of the CRPC, 1973 for quashing of the Naharlagan PS case number 5202 under section 324 of IPC, which was registered as GR case number 6202, whereby this application has been made out because both the parties have settled this matter outside the court. So, Your Honor, this was an
Joint application.
yes, joint application. We pay with this one mutual agreement that is in page 36, page number 36, where both parties they have settled the matter outside the court with a
Party
concern
in
because
excess, victim is also there.
yes, victim. Victim is Tana Daniel, that is the first party, and Sri Biri Kakum, who is the accused, that is the second party in the mutual agreement, which
What
was
is the stage of the case at present?
it's going in trial now. So charge which was framed was 324, which is non-compatible section, that is 324, which was not compatible in the trial court. So we, after when both of them has cleared their confusion regarding the incident, because the 161 statement of the witnesses also clearly they declared that none of the people who present at the spot that had seen that the accused person, he was hitting the complainant. So whereby complainant, everybody was drunk at that time, and when the complainant this one filed, he also at the very moment could not see the blood was coming or anything happened, but on after reaching the his home, then only he came back and saw that
So then
previous blood was
why
there.
the complaint against this?
Yes, yes, it was misunderstood because in the drunken condition, everything happened. And because of the statement of the 161 of the other witnesses, clearly they have stated that they none of them have seen anything and no blood at the very spot. Because
Have you annexed the 161 statements of the victim?
161 statement that are in here.
Yes,
in
you have-
type
you have
copy.
annexed, annexed.
Yes. I have typed them
The
in.
incident took place when?
Incident took place in Naharlagan, G Extension Market.
No, that took place on, where, sorry, when?
When it was in 26/4/2002. For 26 night in the evening. So FIR was
And your
made.
compromise deed is executed on 13th of September.
Yes. Agreement
More
was
than-
recently.
after more than 1 year.
Yes,
Why?
because here the complainant himself also was in drunken condition and he was confused whether it was hit by him or it was accidentally done. Because when this case came, then only he realized that he has given this complaint also, and whereby the 161 statement of the witnesses, they again clarified that nothing happened. We rescued you and you have been safely went away from there. So nothing happened. But after going out from the spot, that anything may happen to him because he was in drunken condition and he left out there with the bike. So very next day on 27, next day only he went and made the complaint. So thereby he got the confusion because he may be accident on the way also. Anything may happen because very incident, nothing happened. No blood, no injury, nothing happened. That was the 161 statement of the witnesses who were present and rescued the victim. So they clearly stated, and he himself, after hearing that one, he said, like, I made the complaint on drunken condition, and it was my confusion, I think. So he now came with the settlement with the accused person that whatever he was done at that very moment was in the drunken condition, he was in confused. So after hearing the 161 statement of the witness, everybody were friends. They all were friends. They were at that moment they were having this one gambling, I think, with alcohol drink with wine. So this happened. Nothing intention, nothing, and even this one medical injury report, MLC, that is in page number 35. Your Honor, may see here also the MLC report is of simple injury. Nothing it was done. So when after going through the trial also, when there is no any conviction, that could be only remote and blink. So it only be harassing for the accused and plus also for the complainant and the witnesses. Even the witnesses, they are in like others are in SEPA. They could not come every time. And another that main accused person who is outside of the state every time working this one because he is doing central contract work. Even the complainant himself is a gastric person and he is sickly every time and he is also not coming. Even arrest warrant is coming for the this one complainant also. He is also getting harassment here, and even the witnesses, they are getting harassment. Accused person is getting harassment because of this trial process, because they have to come and examine and give the witnesses. So, Your Honor, after having this settlement, so it will be better. I have prayed that it may be quashed.
They lost the complaint and again now the prosecution is harassing them.
No, court summon is
them,
harassing them
harassing.
because they have to come for the cross examination.
They have to come.
So, Your Honor, because of this only, now they are cleared with everything, whatever had happened at that very incident. Because if trial goes also, nothing would be there. So, because
Yes.
Lordship, the page Lordship 39 Lordship, the next date fixed on 5/2/24 Lordship for the necessary order.
For necessary order for what? As they are not appearing or what?
Lordship, on that day, Lordship, the accused person was absent due to they are showing some course or some ground, Lordship. Then that absence is condoned Lordship on that day. And again, that
What is the
next
stage
date.
of? Stage at this stage is, it is the stage that the, I mean, evidence stage.
For appearance Lordship, I guess so. As per this order Lordship, it may be called for appearance Lordship. On that day, that accused person was absent, so his absence was condoned. They have given some reason behind that absence, Lordship. And Lordship, next date fixed on 5/2/24, the next month Lordship, for necessary order. So, Lordship, this is Lordship mutual settlement Lordship between the two parties Lordship. But Lordship, as per this statements of the parties Lordship, it is appear that this attack was done Lordship, but the attack was simple in nature. Is this medical, the report is there, Lordship,
Yes,
in
I have-
annexure, Lordship,
Yeah, we did 35.
page, page 35, Lordship.
Cut injury in the chest.
Lordship.
Then do you need
Otherwise,
any-
Lordship may do, Lordship, on the scan copy of the LSA may be called for.
Do you want this kind copy of the?
Lordship, because Lordship, because 5/2 is approaching, Lordship, next week only, Lordship. The next date is fixed, Lordship. On that day, what is necessary order will be passed, but we'll see after that, necessary order can be passed by this court, Lordship. The 5/2 is fixed for necessary order, Lordship.
My lord, this necessary order is for the Honorable Guwahati High Court. I have prayed that we have been compounded this one settlement agreement outside the court. So I'm going to file before the High Court for the settlement, quashing of this FIR. For that only they have given me the time. Okay, then you go to the this one court, and from there you bring out the order. That is the main this one for. necessary order
reflection
there.
in the order? No, your submission has been recorded by the IO, court.
Yes, it was
It is
recorded.
recorded
Yes.
by the court,
Lordship,
then they are going to file an.
Ah,
yes,
settlement
Lordship,
between the
the,
parties.
Lordship, it's page 39 is there, Lordship. The largest cause for the accused has submitted the matter has been settled between the parties. However, the case is registered under section 324 IP, which is non-compoundable. Therefore, the parties are going to file necessary application before the Honorable Guwahati High Court and prayed for adjournment. This is their Lordship.
Yes, I have already.
Then can be Lordship, it can be done as Lordship till now Lordship, it can be Lordship,
No, no,
interim maybe.
question is necessary order, the court fixed the thing for necessary order only because of their prayer,
Lordship,
that they're going to file an petition for quashing before the Honorable High Court.
Lordship,
That is the reason the court fixed it for necessary order, so that
Lordship,
any order or things can be produced before the court. That is
Lordship,
why it is fixed.
Lordship, this is also after court, Lordship, if necessary order may pass, Lordship, whether it can be quashed or it can be, Lordship, only interim may be granted for now, Lordship, so that next that, Lordship, that
No,
order can
we
be.
are not on that. The
On it.
question is that it is a case where they have may enter into a settlement. On that basis, they hold an application or filed an application before the learned court below.
They have
stating
applied the
that-
court that they have mutually settled the,
No, that is
Settlement,
done, mutually settled this and so going to necessary application before the Honorable High Court.
Lordship.
In the pursuant to the mutual agreement or
Lordship.
settlement, whatever.
this is
If
Lordship,
they arrive at a mutual
Lordship.
agreement, in that case, they will approach the Honorable High Court for quashing and all.
Lordship,
Because question is, it's a non-compoundable acquisition, 320 will be not be applicable.
Lordship,
That is their, that is the reason most probably why. And because it is not the case that accused was absent without any step. He was
Lordship.
absent with step.
Lordship,
because
yes,
petition
Lordship,
was filed on his behalf. And they raised the issue that they have entered into a compromise. That is the thing.
Lordship,
Apart from that, this is that is why the order, the case is fixed for actually necessary order.
Lordship.
It's not that, so do you want to, what do you want to say now?
Lordship, my submission is
After
with,
5/2, why should be waited till 5/2, or is there any reason, or if anything is, and then it's okay.
Lordship, as per their statement, Lordship, their fighting was their Lordship, and they have,
Fighting was
yes,
there,
injury
they were
caused
under
and simple
alcoholic- under
injury,
influence of
Lordship,
alcohol, that is there,
Lordship.
and.
Injury was
in
simple,
that
then,
In that
Lordship.
context, the matter, the scuffle was there,
Lordship.
and that had happened.
Then it can be fit case for the Lordship, quashing Lordship, because they're simple
What
in
I
nature
think
and
was
between the two parties,
unnecessary
Lordship,
there.
Lordship.
Victim and this petition, joint petition is filed by the victim and the.
Accused
appellant
person, both
slash
of them,
victim,
Lordship.
both of them.
Lordship.
Otherwise,
Yes, Lordship.
reason for keeping the same for necessary order is only reason that there may be what order the High Court has.
Then
passed.
that's why,
But
Lordship,
that is
that's
why
why.
it is not with progress and
Lordship.
in other words, it is stayed or necessary order, fix it for necessary order,
Lordship.
that is the reason. Third MS.
Kirimi.
Third MS. K. Third MS K. Dhoni, the Danic Council for the petition of the third MS. I have it in the petition PP appearing on behalf of state respondent. This is an application on section so and so, in connection with so and so, for quashing and so and so. It is submitted by the Danic Council for the petitioner that a joint application has been filed by the victim. BD Kakam, the petition number 1 is the accused,
Yes.
filed by the accused as well as victims as complainant, as petition number 1 and 2. 1 and 2 for quashing the criminal proceeding pending before the learned JMFC. Learned JMC where?
UPR Lordship.
UPR, learned JMFC UPR. Under GR case number 62, 2002, under section 324 of IPC. It is submitted that on the night of occurrence, on the day of occurrence, there was a scuffle between two groups, and as all the accused, as the accused as well as victim and other persons were also under influence of the alcohol, there had some scuffle. I mean that during that scuffle, the present victims as complainant sustained minor injuries. But there was no intention on the part of the petitioner number 1 to inflict any injury on the respondent number, on the petitioner number 2. However, in the process, during scuffle, that had happened. Further, she submitted that from the other witnesses, from the statement of the witnesses recorded in section 161 CRPC also, it is seen that they are not aware as to whether the accused inflicted any injury on the victim. However, the victim, as all of them were under the influence of alcohol. However, later on, the petitioner number 2 lodged the complaint / FIR against the petitioner number 1 with the allegation of assaulting him with a sharp object. As the matter has already been compromised, and sorry, in person to compromise between the parties, they have also entered into a mutual settlement agreement dated 13th of September 2023, wherein both the parties have settled their differences and misunderstanding, and misunderstanding, and it is also stated that they will not have any, and their differences has already been there is no differences among them, and they will live peacefully, and the incident had only happened due to influence of the alcohol. It's further submitted by the learned counsel for the petitioner that as the matter has already been settled between the parties, neither the victim nor the other witnesses are interested to adduce evidence in the court against the present petitioner number 1, and hence there is no chance of and hence chance of conviction is very remote and weak, even if the proceeding is allowed to be continued. Next, accordingly, it is a fit case wherein where the court can exercise the power under section 482 CRPC for quashing the criminal proceedings, so and so. Next, in this context, Ms. Al-Magedi Lani petitioner has submitted that as per the order dated, where you have annexed the order.
Page number 39.
Order dated 3/10/23 Lordship.
As per order dated 3/10/2023, the court is fixed on 5/2/2024 for necessary order, and accordingly submitted that on 3/10/2023, the accused was also remained absent before the learned court below, and accordingly she submitted that the scanned copy of the LCR may be required may be required in that regard. However, she admitted that both the petitioners were already entered into an agreement for settlement, and in person to the said agreement, they also intimated the learned court below that necessary application will be filed before the before the High Court.
Please, my lord.
Yes.
My lord, this application, my lord, in fact, which could have been a civil dispute, my lord. Now it has been, I'm not named in the,
Criminal character.
yes, I'm not named in the FIR. What happened, my
You
lord?
are not the name accused.
Yes, ma'am. What happened, my lord, that in Holongi area, my lord,
Hmm.
I was given some land by some person, ma'am. Because
You were
those,
given some land by some person.
yes, ma'am. We went there to do some farming, and there, and at that time, I'm not basically, I'm not from that area. So when we went there, in fact, the localites, thinking that we were trying to occupy their land, we were in fact assaulted, man. We went to clear the jungle, and of course, there was a gun, my lord, but that is a elephant infested area. It is near the Assam Arunachal border. So that one gun was there. That was a licensed gun, and that person, owner of the gun, has also been arrested. Man. That is there. Man. But what
Also
happened?
arrested.
Yes, already arrested, ma'am. But what happened? In fact, we were overpowered, ma'am. Being the localites there, they were huge in number. We were around 14 or 15 persons who went to clear the jungle. They came in around 100, more than 100 in number. They overpowered us, took away everything, the guns and everything they took away. And in fact, in the process, we were assaulted. And in fact, I have annexed the medical certificate of my wife also, ma'am. We were assaulted, ma'am. Now,
Your wife also got assaulted.
yes, ma'am. It is at page 11, ma'am. Anu Nangram, she was assaulted. We were all assaulted, ma'am. This is the medical prescription of my wife. The incident happened on 28
So
12.
who are you? You purchased the land or who are you?
Not purchased, my lord. Basically, in those areas, my lord, what happened that earlier
Illegal, you are the illegal encroacher.
maybe encroacher, my lord. We cannot, at this stage, what happened is that, my lord, those areas where is the place where the Chakma, Hajong, they were settled, my lord. Chakma and Hajong people and Karbi people, they were settled there, my lord. And after the start of this airport, my lord, those people had given up those land, man. They were not doing any farming activities there, man. But the place which I had occupied, identified, there was one person, one Karbi person. We took his permission. He said, okay, this has been in our possession since 1950s. His grandfather, everybody did that farming. Now, since the inauguration of the airport, since it was acquired, we have stopped that. You can do the farming, but you look after it, and then if you wish to pay something later on, we agreed to that. So that's why we went and cleared the jungle. And in fact, we were assaulted. Now on this, there's a case of complaint and counter complaint is also there by one of the named person in the FIR. Incident happened on 28/12/2023. And FIR is also there. FIR is at page 16. I'm not named, my lord. And against this FIR, my lord, the person named in the FIR in the it starts at page 12.
Some 4 persons were.
4 persons are there. And of course, unknown persons they have mentioned, ma'am.
So as you were in the group, so you
Yes,
have the apprehension. of being
apprehension.
arrested.
And on the last occasion, my lord, on 10/1/2024, my lord,
You are an interim.
protection was given, my lord.
And
I
where
have,
is the FIR filed by you?
my lord.
Is there any counter FIR?
Yes,
filed by
counter
you?
FIR is also there. It is at page 19, my lord.
Hmm.
On 28th, the incident, 28th December incident happened, my lord. We went to the police station, my lord, but when we were there, the OC informed that those localites, they are also coming to the local police station. So he advised us to leave. And on the next day, this 29,
Last day.
yes, because the OC also implemented, there might be further altercation. So on 29 this one. On 10th of January, I was granted interim protection, man. I've already appeared, man. I've already given my statement, and I intend to cooperate, man.
Yes.
Lordship, so this accused name was not reflected in the FIR lawsuit, which is lodged on 28/12/23 lawsuit. But during the course of investigation lawsuit, the IO lawsuit, they visited the accused house lawsuit. Then they have learned that the accused had left the home lawsuit and evading the arrest. And lawsuit on the go, but they don't, maybe the accused of lawsuit, they apply for the AB lawsuit. But lawsuit, now they have complied the lawsuit court order, and they have arrived the IO, before the IO lawsuit, they have give their statement as well lawsuit. As per the statement, they have denied lawsuit any involvement lawsuit. But lawsuit, if lawsuit is inclined to lawsuit to make this interim as absolute, then it necessary lawsuit, the terms and conditions may be imposed. So that till the completion of the trial lawsuit, investigation lawsuit, he may be lawsuit, whenever this IO call for lawsuit, he may be present before the IO lawsuit for necessary lawsuit investigations. Because lawsuit here, this status of the case is revealed that lawsuit, those who have arrested lawsuit, this accused also, they are not revealing lawsuit, this further accused number, because this accused, this last number lawsuit. The lawsuit do investigate that all the above prime accused who has lawsuit taking shelter lawsuit through the interim protection from various court lawsuit, they did not disclose the name, address of their associate. They are the influencer and encouragers lawsuit. So lawsuit, the proper investigation is still going on. So till the investigation is completed lawsuit, the accused may be cooperated before the IO lawsuit.
Mr. Disoki,
My lord.
or Mr. Disoki, the Learned Counsel for the question, also have the Learned additional duty, appearing on behalf of said respondent, listen application under section so and so, in connection with so and so. It is submitted by the Land Council for the petition, but after obtaining the interim pre-arrest bill dated 10/1/2024, he appeared before the IO, and his statement is also recorded by the IO in connection with this case. He is further ready and willing to cooperate the IO in the investigation of this case if he is granted with the privilege of the arrest bill. Further, he submitted that it is a fact that on the day of the incident, he went to the land for cleaning, and as it was given by the person, what was the person?
One Talo Langne, my lord. This is paragraph 19. I've mentioned the name.
Talo,
Langne.
one person.
We went to
namely-
clear the jungle.
person namely
Paragraph 19.
namely Talo Longning,
Langne.
a local
Mawam Rungi.
Longne, a local Kirby resident, allowed the petitioner and the other persons to clear the land, claiming that he is the owner of the said land since 1951. But when the petitioner, along with some others, went to the place of occurrence, a group of more than 100 people of local area came to their place, and they snatched away all the belongings and Dow's license gun, etc. And also assaulted the petitioners, some persons of the petitioner side, and even the wife of the accused petitioner got assaulted in that process. In that context, they also lodged a counter affidavit, a counter FIR before the police station. However, when they went to the police station for lodging the FIR, the police personnel asked to come later on, as there may be situation may be deteriorated if the local persons also arrive in the police station. He further submitted the person which was along with the petitioner side with a licensed gun has already been arrested in connection with this case, and he also produced the licensed gun along with the license before the IU investigating authority. Next one. And the additional PP MS Hage further submitted in this regard that from the statement made by the present petitioner, and from the statement of the other petitioners who also obtained the interim pre-arrest bill, it revealed that they did not disclose the entire facts of the case, though their statements were recorded by the IO in connection with this case. And accordingly, they submitted that for proper and next investigation of this case, their further statement or cooperation will be needed by the IO, and hence he submitted that even if the petitioner is allowed to complete the pre-arrest bill, he may be certain terms and conditions may be imposed on the petitioner so that there cannot be any so that the IO can so that the investigation can be progressed without any so that just and proper investigation can be done by the IO. Considering the submission made by the Land Council for the petition, considered by the submission by the Land Council for both the parties, and also considering the notice available in the case diary and the other aspects of the case, I found that further custodial, further don't give custodial interrogation may not be necessary in this case. However, certain conditions may be imposed to the petitioner so that he can appear before the IO as and when it is required for the purpose of investigation. Accordingly, I find it a fit case to extend the privilege of free arrest bill to the accused petitioner. And the order of entering free arrest bill dated 10/1/2024 is hereby made absolute with the following terms and conditions. You give the conditions because there are no such conditions. Give some conditions. There will be some conditions to abide by all these
Yes,
conditions. With the above observations, so it's okay.
Obliged lordship.
okay.
My pleasure, Lordship.
You have
Lordship,
come
this-
today or yesterday you have come?
my lord, today,
Today.
today morning.
It's a
Lord,
matter appeal.
my lord, yes, this matter will has been arisen from the judgment and decree dated 24/7/23 passed by the district judge Alok, declaring the marriage certificate of the appellant and her deceased husband as null and void. Upon an application filed by the respondent for declaring the marriage certificate of the appellant and the deceased husband as null and void, claiming that she is the first wife. The respondent claiming that she is the first wife. In that case, the issue-
Succession and all are also.
the
pending.
issue here is that whether a third party can challenge the validity of a marriage certificate of others. Because as per section 24 of
Now,
spec-
who is she? Respondent number 2.
Uh,
She is the first wife. She is the
claimed as first wife,
claimed as-
claimed as first wife.
Then,
I think it needs a long hearing.
yes, I think so.
It may be fixed for hearing.
Anyway, it was listed in the order column.
Yes.
So you have appeared for the private respondent?
Yes, my lord.
How many? Only sole respondent is there?
One respondent, madam.
Only one respondent?
Yes, sole
We
respondent.
already appeared.
Yes.
It can be admitted from hearing and we'll admit.
Yes, 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 madam.
It can be listed for hearing. Yeah, then in that case, it will come under the hearing. list.
Hearing column.
Hearing.
And interim also may be continued. Interim was there.
dated?
Yes. Another IA was there, in that interim was given till returnable date.
On the strength of that order, whether they placed it, order of the Planet Code below in other
Yes,
petition
yes,
for-
operation of that order was stayed, basically.
No, on the strength of that order, whether she applied for any successor certificate or whatever in there, or the. whether
Yes, she can.
She can, yes. File is to be declared in the council for the appellant and also have Mr. Your name?
M. Doji, madam. M. Doji.
Council appearing on behalf of the present respondent. No, appearing on behalf of the sole respondent. Do we need the record and all?
Yes,
Yes,
LCR may be
madam.
called for also.
LCM will be called, madam.
Accordingly, it reveals that the service is already completed. Let the LCR be called for. Admit the appeal for hearing. List the matter in the hearing, list the matter in the hearing column on the next date. Let the matter be posted, let the matter be listed after 4 weeks. Posted.
If possible, date may be fixed.
As per your convenience, we are going to.
12? Yes, okay. Much obliged.
My lord, this
I
is,
think also, I don't think,
The service is not completed yet. Service is not completed.
service is not completed.
I think the service is not completed.
It's still awaited for service.
Still
it is
awaiting.
awaited. My lord, in that case, I may be allowed to publish the notice in the paper because the victim where she is residing is within this capital complex.
No, your lordship, as far as I believe, your lordship, even paper publication in criminal cases, after all the steps have been taken, your lordship can,
Here, we have stained the, through only ID card. I mean. through-
yes, yes.
So, if, as it is a criminal matter, I think, it can be issued to jurisdictional police station routed through the, office of the, this PP. That can be done for the first time. Because if, as per you, the person resides here or here,
She is residing within this capital complex. I think
but
she
you
is
don't have
residing,
any proper address of her.
the proper address is there. She is,
Address is here.
that is there.
No, your lordship, if I may explain, your lordship, if your lordship will come to page number 3, your lordship. The victim was made a party by name, which was objected on the very first day, your lordship. That this, her name may be,
That has been already
yes,
done.
and therefore the amendment was to be made by the learned counsel, your lordship. Subsequently, your lordship will see, though the father's name is there, but then care of is given of Child Welfare Committee, Itanagar. I'm not sure if this is the proper address, your lordship. Because if it's, the father of the victim is given, your lordship, care of would not come under the Child Welfare Committee.
My lord, in this case, father was also accused. Although he has
Her name of her father is, now name of her father is given. And she care of child welfare committee, Dhanagar. The learned counsel for the appellant submits in this regard that, as per his information, the victim is still in the custody of child welfare committee, Dhanagar. Accordingly, let a press notice be issued to the respondent number 2 through jurisdictional police station routed through the office of the learned PP. Mr. Where we have called for the LCR has. received-
Yes, we have received the LCR, your lordship. Meanwhile,
LCR
paper.
has already been received. Let the matter be accordingly listed after 4 weeks. And this, yes, you have filed any objection here?
Not yet, your lordship. We won't be filing our objection as such. With regard to the IA, your lordship, with regard to the IA, if I may,
Regard to I am asking you.
if I may pray, your lordship, since the LCR is already here, if paper book is prepared, your lordship. Because while,
What is the term of conviction?
10 years, ma'am.
10 years?
10 years.
Now, definitely paper book is there,
yes, your lordship.
but victim is not there. Even if suppose on the name date, suppose victim is remain absent after service of the notice also, in that case, we can appoint an
Yes,
legal
legal aid
or an
counsel.
advocate, so that matter can be heard. But the question is the paper book is already ready.
It's not ready.
Paper book is not
LCR has
ready.
come, your lordship. If paper book is made ready, your lordship, then if they are pressing on IA, we can rely upon the paper book and make our submission accordingly, your lordship.
No, my lord, the paper book is not necessary to consider the IA. Paper book is for argument in the main case.
No, not absolutely not.
No.
No, I guess,
Well, let me-
definitely, because if LCR is there, most probably it may be submitted from, but if the paper book is ready, then it would be much easier for the anyone, for us, for the
Because
PP, everyone.
some of the documents are not annexed along
But
with the
they are
petition
taking time.
copy, therefore.
Along with the petition means, you have received the LCR.
LCR,
has
the
already been received.
registry
So,
receives the LCR.
Next, do one thing, next time, if, and that you have to not prepare,
Yes, sir.
or if you have not filed any objection,
Yes, sir.
let the matter be heard on the next day, and we will give a direction to the registry to prepare the paper book.
Paper book, your lordship.
Even if suppose paper book is not ready, but you made your submission on the date next week.
Next date, your lordship.
I'm going by the case record.
My lord, today I may be considered.
Huh?
Today I may be kindly
No, if
considered.
she submits, then I don't.
No,
have
no,
it.
because my lord, it is 3 months since I have filed the appeal. And still they are going to take time.
We are not taking time, Your Lordship. The service is not being completed and that's therefore.
That is the problem.
That's
That
the
is the
problem.
problem.
Now, see, the IA itself, the notice was issued and it was awaited, I think. So you cannot directly say that the prosecution is taking time, but the question is that definitely 3 months has already been lapsed.
Yes,
That
madam.
is the issue. So that's why I'm saying that even if the paperwork is suppose not ready, in that case also the matter may be hard because go by the case record and submit.
My lord,
accordingly.
as per 389 CRPC,
Yes, yes, we had the 89.
there is a provision for suspension of the
No, we are not
interim
denying.
order.
Yeah, the submission, the provision is who denied provision is there.
And it does not say
But
regarding
we have to
paperwork.
give a chance to the prosecution, no? In that case, if it is a 10 years of the punishment, sorry, the conviction is of term. of-
Then your lordship may pass an order. Even if paperwork is not ready, the IA will be considered in the next date. Otherwise, they'll take time again.
No, I would suggest, Your Lordship, why I'm harping on the paper book is that the IA does not contain, it contains only the judgment, Your Lordship. Now, if they are pressing on the suspension of IA, Your Lordship, while suspension of the IA, even the antecedent of the accused has to be seen. How was he during the entire
Everything,
trial?
everything.
Therefore, I'm seeking for the LCR, paper book, Your Lordship, because otherwise, with the half document, Your Lordship, my submission and leading to the court would not be in.
Make submission to the date that we don't observe, make any observation in that regard. However, we'll give a direction to the so-and-so. Heard this as so-and-so, the land council for the, in IN, and also heard MS so-and-so, the land acquisition people, payment so-and-so. From the office note, dated so-and-so, I got a question, so-and-so, it reveals that the service is still awaited for response number 2. However, the notice is directed to be served, press notice is directed to be issued through the jurisdiction police station in the same address, routed through the office of the learned people. The learned counsel for the appellants, as petitioner submitted that the appeal, we have 3 months left.
3 months left.
The appeal is filed prior to 3 months and the petition under section 389 CRPC is still pending. And accordingly, he stressed that to dispose of the petition. First, MSTG, the learned additional PP submitted in the paper that for some document and for their proper submission, the paper book is required, though the answer has already been received. Considering the submission made by the additional PP, the registry will be directed to prepare the paper book on or before the next date of listing. Let the matter be accordingly listed. Here too, we have given 4 weeks time. So here also you want 4 weeks or another date to be fixed earlier.
Yes,
Any-
madam.
Any date, 4 weeks, Your Lordship?
Huh?
Any date after 4 weeks, Your Lordship?
After 4 weeks. Then
Yes,
in
as-
appeal also we have to fix the date.
Yes,
Because appeal we have fixed for 4 weeks.
yes.
Okay, 4 weeks.
Because,
let it be-
because if,
Let it
where
be
I'm-
same time.
yes,
4 weeks at the latest date fixed to by the list.
But my lord, in the next date, IA be considered.
I may be heard on the next date.
and also, Your Lordship, this is since this is under POCSO, Your Lordship will see that the presence of the victim is mandate, and therefore Your Lordship is rightly suggested that on the next date, if the service is also not complete and there is an urgency, legal aid can be considered, Your Lordship.
That may,
Even while hearing the IA also
that may be
it
approved.
is to be-
In case the service is not completed on the response number 2, one legal aid counsel may be appointed on behalf of the victims that respond.
Obliged.
deeply.
May I please, Lordship?
Yes.
Lordship, I am for the sole respondent in present case. sole respondent.
You are appealing for the sole respondent.
Yes, last occasion on 29/11/2023,
Huh.
the petitioner, they were absent. Then I had made a prayer before this honorable court.
Acha.
Since they have filed this case, the take of the case is that by the virtue of money education petition by the learned Civil Judge Senior Division UPR, the petitioner was arrested as a civil imprisonment.
When they remain absent, you have said?
29/11/23. 29/11/23. This honorable court has been very
But
specific.
thereafter, another date was there, 23/1/24.
That day, this has been made adjourned.
Acha, it was that.
Yeah, and now today the next is coming up. In 29, specific order has been made by this honorable court. Since they are not turning up, if next time they are not turning up, the interim will be vacated. That was the clear order from this honorable court. The fact of the case is, Lordship,
When interim date will be considered, where it is written? Or
petitioner, they had protected by the interim. He has been released from the prison. He was arrested as a civil prison by the virtue of the money education petition.
Acha, acha.
Then
He is
thereafter,
under
he
civil
appeared
prison.
before this honorable court stating that if I will be in linguist inside the jail, I am incapable to pay the money. In my bank account, money is lying. I may be allowed to go outside and within 1 month, I am ready to pay. After getting the interim, now it's going to be 5 months. Interim was granted, Lordship, on 6 September 2023. Interim was granted to the petitioner. Then thereafter, nor the petitioner nor the counsel appear. No, my money has not been returned. Even he violated the learned trial court. Even he violated this honorable court's order. Therefore, my humble submission on the basis of order passed by 29/11/2023, interim may be vacated and this civil revision may be dismissed.
Now see, on the 29/11, as we have submitted that, yes, it is our case that the petitioner was absent on call.
Yes.
But on subsequent date, that is on 23rd of January,
Yes.
he again appeared and there was some prayer for adjournment. I don't know what. was that.
We had made, because by mistakenly from the bench assistant, that I was, till the last moment I was at that day. Then when we came for the adjournment, because this honorable court time was not permitted, then when we asked, then said it has been already adjourned. Then we are very shocked. Then we have contact with the other party. Then
But,
they said they have never
but here
appeared.
most probably your
Then we made the mention for the 29
29.
for today. There is intention. Humble submission. When interim may be vacated, case may be dismissed. No, it will respond when the ex-CRT is published. Submitted their also petition. Next, petitioner
of September.
6th of September.
Yeah, please go ahead. Now, my lord, I'm appearing for respondent number, sole respondent. I'm appearing for sole respondent. in this case.
You are appearing for sole respondent.
Yes, my lord, in my lord, IA 68. my lord.
No,
And they
you're
have-
for the sole respondent.
Yes, my lord, yes, no, IA 68.
Here, it is what, criminal petition? or-
Yes,
No, my lord,
criminal
this is
revision
for-
petition, Your Lordship.
My lord,
Achha,
this
criminal
is
revision petition, okay.
interlocutory
With the private
order.
parties. Huh,
Interlocutory application for condemnation of delay.
interlocutory.
Yes, please.
Ah, yes, interlocutory application, yes.
I will file my objection. ma'am. Because for 3 months,
What was the delay? How
delay
many
is
days?
31 days,
Huh?
ma'am. 31 days.
So can it be condemned? Or you have any strong objection?
Yes, my lord, I may be given some
Now
time.
see, if
to
we,
file
if
my
the case
objection.
under section 138A, if suppose
Yes, ma'am.
delay is condemned.
My lord.
I'm saying delay is condemned and if the matter get compromised during the pendency of this revision petition, suppose. In that case also you may be benefited.
My lord, in this case, my lord, my lord, please, right, my lord, in this case, my lord, situation is little bit different, my
Different,
lord. Yes,
okay,
my lord,
okay.
that's why, my lord, okay. I'll seek my
So
lord 3 weeks
you are
time.
you are appearing for K. Tama,
Petitioner, yes, Your Lordship.
your good name?
Chitring,
Mr. P. Hearing, the learned counsel appearing on behalf of Mr. K. Tama, the learned and this counsel for the petition. And so heard, yes.
H.
So,
Lampu.
huh?
H. Lampu.
H. Lampu, the learned counsel appearing on behalf of respondent. You have
So-
filed Wakalatnama,
I have only filed today only.
so respondent, and he has already filed his Wakalatnama on behalf of the respondent. He further submitted that some more time would be required to file their written objection against the order of, against the petition for condemnation of delay. Prayer allowed. Let the matter be accordingly listed after 2 weeks, enabling the present respondent to file the written objection. Written objection posted.
may I please, Your Lordship? On behalf of the,
This is highway,
yes, Your Honor,
yeah,
yes, condolation of 4 days.
इसका main petition कहाँ पे? It is under CRP 44 AP.
Yes, my lord.
This is the condemnation.
Condolation, aye. And regarding, Your Honor, in the earlier time, 2 times the steps to be taken, but due to some problem, the address and the respondents are not traceable.
Now, yeah, is there any chance of getting the
So I'm taking,
the
pray for the
present
fresh,
proper address?
yes, I'm getting some new addresses, Your Honor, present address within the Papumpara district. So this is the 2 address, recent, I got it.
Okay.
So this
So
honorable,
you,
may I allow, my lord, if taking the fresh
Please.
step,
what is this?
this is a 2 address, Your Honor. I enclose
No,
the 2
you-
address.
Already order is there actually. On 9/10/2023 itself, then order was passed.
Yes, my
That
lord.
will be, fresh steps will be taken
Yes.
in the proper and recent address of the so and so.
That's true, Your Honor.
So I don't think it
After
should be
taking
negative.
the steps, my lord, till that, no any respondent receive any counter, any record of the, like, from the post or the as usual process, my lord. So I pray for the fresh step regarding the serve the notice and other steps, Your Honor. The I and the main
No, no,
petition.
in phase, you have taken your fresh steps.
You already taken 2 times, my lord. This is 3rd time. And moreover, my lord, that the same parties, the one title suit and the domestic violation case going before the session court and the JMFC court till yet. The counsel is, the respondent side is Nending Gago, sir.
So
Regularly
Dusty, we
appeared.
want to allow you Dusty.
Yeah,
sir,
Dusty
to
also, if possible, my lord. As usual, post and Dusty, my lord.
Dusty.
Yes.
So you again want to take fresh steps
Yes, my lord. Last,
and we'll allow you to Dusty also.
Dusty also, my lord.
Heard Mr. Your Mr.
M. Bagra?
Heard Mr. M. Babla, Devanagari Council for the petition.
Yes, my lord.
As per office note dated 25/2/2024, the ID card is not yet received back for the sole respondent. The Learned Council further submitted that he took steps in two consecutive occasions for the sole respondent on the in the new address, new and proper address. However, the notice is not yet returned. Further, he submits that another fresh steps may be taken to the sole respondent through as usual process and who registered AD. And in the same time, he also prayed to serve the notice to Dusty Mode,
Dusty mode.
stating that two cases are already been, one case is what case? One case?
The average case, my lord.
One title suit.
Title suit, my
One
lord.
title suit and one
Domestic violation case
one
going
title
on the.
suit and one domestic violence case is already pending before the learned trial court below in here.
Here, my lord.
in
One is
India.
the session court, district session court,
In
and another
India,
one,
one
yep,
in
yep.
the session court and one in the
JMFC court, yeah, my lord.
in the court of JMFC.
JMFC, yep, yeah.
Considering the submission made by the Learned Council for the petitioner, let fresh steps be taken on the sole respondent through registered AD as well as to
After 3 weeks. Demobilize.
we have solved this and it is founded, it is purely an interlocutory order. And there is also no explanation if any prejudice has been caused to the petitioner, this petitioner, and accordingly, we do not find it maintainable in this present form and same stands dismissed.